In the past month, the Italian Supreme Court granted two seminal decisions concerning the doctrine of equivalence. The first decision put the word end to the notorious LISEC case, which dates back to maybe 20 years ago and ended up the first time before the Supreme Court with the seminal decision in 2004, which is probably still the leading case concerning the doctrine of equivalence in Italy. In that decision, the court stated that in order to see if an infringement took place, the judge must look and consider if the modification is obvious compared to what is claimed in the patent. After that decision, the case was sent back to the Court of Appeal, where the patentee, by the way, full disclosure, we assist the patentee, where the patentee won and the court found infringement. However, the other party appealed again and the case went back to the Supreme Court. Now the Supreme Court dismissed this second appeal for procedural reasons, actually, thereby confirming, at least implicitly, that the 2004 principle is still valid. An explicit confirmation that this principle is actually valid came from another decision, which is again recent, dates back to the beginning of this year, which involves the Barilla pasta company. In that case, the Supreme Court confirmed that the analysis should depart from the principle set in 2004. However, the judges added that you must also look if the modification or the modified product still uses, at least partially, the invention, thereby preventing or putting some obstacle to the so-called inventing round. These two decisions, therefore, help the interpreter to understand the doctrine of equivalence in Italy and, at some extent, try to give the patentee a fair amount of protection. Now let's see if the lower courts will be able to correctly apply these principles. Of course, we will keep you posted of the developments, maybe also here on Lawyers Monday.